Yes, thank you. Mr. Speaker, I rise to make a few brief comments on this bill that's before the House. The broad point that I wish to make is really consistent with what has been said here by the member for St. Andrew South East. I must say that for me, for a bill dealing with cybercrimes to be brought to the House in 2026, which is addressing the contents of a Joint Select Committee report written in the first half of 2023, and which does not fulsomely address the very serious issues which have arisen with the advent and pervasiveness of artificial intelligence, is a great disappointment. This bill ought to be doing that, because we are living in that age now, and the issues that it presents for our society are real. The law needs to more fulsomely protect persons' images, the image of an individual, their reputation, and the use of their appearance and their voice and other biological manifestations through manipulation to denigrate them, to spread falsehoods, either about them or others, or things that they have alleged to say which are complete fabrications. These are very serious problems. And I think for the bill to come here and not address that is a disappointment. We cannot say that we are protecting our society and keeping on the cusp of technology when we are not. We support these amendments, but they're dated. They are not dealing with the most pressing problem that has arisen in the last 2-3 years. And I hope, Minister, that you will give a commitment, although I see the bill is not tabled in your name, but I hope you will give a commitment that the government will move rapidly to convene another Joint Select Committee to update this legislation to address the pressing issues which have emerged in the last 2 or 3 years because of the advent and the growing power and influence of artificial intelligence, which jeopardizes the society while representing a tremendous opportunity as well. But there are clear and present risks and dangers that come with it that we need to protect the society from. And this bill does not do that. There are 2 other points I want to make. When the minister was giving his opening, he made reference to the fact that there are actually 2 amendments in this bill that make the same point, Clause 2 and Clause 11, which insert after the words any key or key, the words whether electronic or digital. And I asked, hoping that he would explain, what is the difference between electronic and digital, those 2 concepts here? His response was less than accommodating and unnecessarily so. Yes, especially coming from a minister. I mean, clearly, if he's not sure of it, if he's not sure what the difference is, there's a technical team here to provide that type of guidance. And I hope we will get it. I'm hoping that we will get that guidance, because the question is a legitimate question, and I would like to understand the difference. Yeah. The other point that I wish to make relates to Clause 5 of the bill, which is dealing with Section 9.
Members. The members on the members. The person is on. The member is on his feet.
Thank you. The other issue I wanted to raise has been mentioned by the member for St. Andrew Southwest. And it relates to the defense that is set out in clause 1C, big C, to the new offense which is inserted by clause 9(1)(a). And it relates to the publishing of intimate images. And 1C speaks to defenses to that offense of publishing intimate images about somebody without their consent. And one of the defenses talks to or speaks to publishing for the purpose of reporting about historical events. Now, I want to know what that means. What are historical events for this in this context? Is a historical event something which you find in a history book? Or is a historical event something which has occurred in the past? And maybe the recent past. It may be last week. So from that perspective, given that this is a defense that will remove the protection to the individual who has had intimate images about them published, it ought to be very clear what that defense is trying to address and what it is not trying to address. And as presently formulated, it is too general, it's too abstract, and it, to my mind, could undermine the intent of the new offense, which is to protect people from violations of their privacy through the publication of intimate images. So, Mr. Speaker, I hope that those two issues will be addressed, and I also hope that the Minister will assure the House as to when a joint select committee will be convened to modernize this legislation, to take into account the new age that we're living in and the risks and dangers that we are all living through on a daily basis in the absence of legislation that adequately addresses those risks and dangers. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. I want to make two sets of comments. One, I want to start with process. The act that we are now seeking to amend is based on a joint select committee that was established in January 2021. The joint select committee substantively had meetings in 2023 and completed its work in May 2023. We are at January 2026. Now, when the amendment to the 2015 Act was done, we had built in a review after a 3-year period. The point I'm making that in 2026, we are now due another review. And the reality is that the work that would have been done almost 3 years ago would not have taken account of probably the most important development in technology over the last century, which is the advent of artificial intelligence. I make this point to say that the lack of timeliness of moving from a joint select committee to a report to amendments affects this particular legislation more than others, because the nature of technology evolves so quickly. And so we have to ensure that, particularly for legislation of this nature, that we conduct the reviews and do the amendments in a timely fashion. There are two substantive points I want to make. First, the issue of reporting of cyber incidents. In the 2015 Act, we deliberately took the position that financial and other institutions there would be a voluntary obligation on their part to report. The experience and the evidence is that when you look at the number of reports in comparison to the anecdotal and the others that you know exist, the institutions are not reporting what is taking place. That has implications for policy, it has implications for a number of other things. And so a recommendation was made that we should move away from voluntary to an obligatory mandatory reporting to the regulator. And in this case, if it's a financial institution, it would either be the Bank of Jamaica or the Financial Services Commission. Now, obviously, no financial institution wants the publicity of acknowledging that there are breaches. But I'm sure if you speak to members here and in the general public, there are so many of us who have been victims of cyber criminal activity, particularly around banking transactions. And many of them are settled almost immediately. In a particular case for me, when I reported it, it was immediately settled. And I came to the conclusion that the bank acknowledged that it was a problem. I indicated I was not at that ATM at 1 o'clock in the morning, and I was refunded my money. But the reality is that these reports are not being captured by the regulator, and it is important that is so. The second substantive area relates to Section 9, which is malicious communication, which is the most controversial clause in this act. In 2015, the Office of Director of Public Prosecutions published guidelines in relation to how the act should be, this particular clause should be interpreted, read. And I just want to encourage the government in the public education to ensure that those guidelines are made available. They're in the public domain, but to reinforce, because we are in an era where people believe that once you're online, you can say and do anything. And because it is difficult for the people who are offended to pursue the matters, people feel they have a license to almost act outside the law. So I want to encourage the dissemination and the inclusion of that report by the DPP's office surrounding Section 9 in all public education going forward on a continuous basis, so that the public is aware that the persons who are prosecuting, both law enforcement and prosecution, and the judges too, can be up to date with how that report dealt with Section 9. I was a member of the committee that did the review, and as my colleague from Southeast St. Mary said, we are broadly in support of the recommendations that are made. But the main point I would like to make is that with the passage of time, we are almost due now another review of this act to ensure that we incorporate the new advancements in technology, particularly around artificial intelligence. Thank you.
Member from Portland Eastern.
Thank you, Mr. Speaker. Minister, I rise to support the amendments to the Cybercrimes Act. I just wish to make a comment on Clause 8, which would be Section 15. And just to point to you what I genuinely believe may bring some fear or apprehension or fear of prosecution in relation to the lack of a definition in relation to the premises that is intended to be covered in this section. So it's not a criticism, it's just a wonder, and in light of what my friend from St. Andrew Southeast would have said, whether or not it's something that could be reviewed. Nothing I say here I think would prevent the passing of your legislation, but just wondering if it's something that we need to look at. In certainly the Dangerous Drug Act, the fraudulent transaction legislation, a lot of the activities are physical. This section, as worded, speaks to two types of knowledge. Actual knowledge, which is the knowingly cause, and then there is the turning a blind eye, kind of strict liability, being negligent. What is a little bit problematic is whether or not how we define who is the person in control of a premises, and whether we can control, as the section speaks about, any act under the Cybercrimes Act. You as a premises owner, landlord, I can go to even the warder, to the minister of the state minister in security, even the warders in the prison institutions, and cell phone access, especially with the malicious communication, whether the premises and how liability comes about by a failure of defining the premises in relation to cybercrimes, because it's not general, or we can't make it comparative to the Dangerous Drug Act, where there's some physical substance that somebody can, or activities in and out of a premises. Youth club persons, community centers can find themselves in trouble with the law because the definition is not restricting or kind of giving guidance out of the legislation by the definition section. So I'm just raising it to say it may be something to consider or review. It won't prevent, I support it 100%, but there was a famous case, Sweet and Parsley, where Lord Reed would have said we're not in the business of turning ordinary citizens into criminals. And a section like this also give police wide powers to enter premises that has sometimes a owner, landlord, sublease, a lessee, or even family members who would not have known in a situation where TikTokers or teenagers decide to send malicious communication, or is in problem with multiple girlfriends and decide the TikTok drama that unfolds, and you find parents in trouble or pastors in churches, youth clubs. Just something to consider. Thank you.
Thank you, Mr. Speaker. I rise to add my few words on the report of the Joint Select Committee to the Houses of Parliament on the Cybercrime Act. I want to say that there is really nothing controversial that I have to say, hopefully, today. That, as others have said, I agree with the direction of the amendments that are made. There is just one little provision that I am opposed to, and I'll tell you why. I listen to that. I know that the recommendations include repeal of Section 15 and provides for compensation of victims of cybercrimes and all of that. As I looked at it though, I was thinking that in as much as we talk about three main incidents that occur in terms of cybercrime as being abusive content, impersonation, and revenge porn, for me, one that we have not paid sufficient attention to is reputation sabotage. Right? And that is as well a big one, and it has been a big one in Jamaica. We look and note that in the first 6 months of 2025, we saw 34 million cyber attack attempts. Huge, yeah? And so all of the various categories, I think, are important for us to look at, and I didn't note enough attention being paid to that. I raise that, Mr. Speaker, because I'm sure you would not be surprised to hear that there are members here and many Jamaicans who every day will come and laud, big up their social media individuals. And when you go and check, you will actually see that some of those same persons are and this is not the first time I'm saying it in the House, yeah? And I do say it because I have been the subject of it. So for me, it is personal and it is offensive that there are individuals associated with colleagues who could be spreading information that they should know is false and that is really meant to cause reputational sabotage and damage. And so for me, that is a big one that I think we need to look at. And I feel very strongly about that. In terms of the one issue that I am concerned about, through you, Mr. Speaker, is is included in Section 9 of the Principal Act and is on page 3, that is 5(1)(c), D, and E, where it says that it shall be a defense in any proceedings for the commission of an offense under Section 1A for the defendants to show that the image that was published, yes, was for bona fide educational, scientific, medical, or research purposes, or for purpose of reporting about historical events. And the only question that I'm asking is, if it is something that is offensive to me, is this saying that these are good grounds for it to be republished or reshared under those circumstances? And is it expected to be done without my consent or without saying anything to me? I'm very uncomfortable about that. And so I want to ask that as a question. The rest that I wanted to say, Mr. Speaker, is not about what is in the bill, but rather what I thought needed to have been addressed, notwithstanding the focus of the Joint Select Committee. As the member from Southeast St. Andrew has said, with the lapse of time, I know that there is, and it should be shortly, an opportunity to revisit the bill and to address some of these issues. And so the first one is really about inadequate penalties, because you would know that there are a number of individuals who believe that the penalties for offenses, that they are not sufficient deterrent for unauthorized access to computer systems. Currently, it's $2 million and up to 2 years, when we have similar jurisdictions to ours that have 5 to 10 years. And so I think that that is something for similar offenses that we should be looking at. And then is the limited scope, yes, of the bill, because it does not fully address, and I think the member mentioned that as well, emerging trends and technologies, yeah, and in particular the issue of spam. Also, the difficulty in prosecution, as many have actually noted, yes, and you will know that the investigative capacity, yes, is not there to give the kind of support that the bill needs for proper prosecution, for wider prosecution, yes? And so I believe we also need to look at the investigative capacity of law enforcement agencies for that. I also saw, I think it might have been pretty close to the time that the Joint Select Committee might have been meeting, a discussion by the Office of the DPP around broadening the Cybercrimes Act to empower clerks of the court to actually seize computers that are engaged in these kinds of activities. And I thought that that was worthy of being considered, and so I wanted to recommend that. And then, as I end, Mr. Speaker, through you to the Minister, I believe that any revisit of the bill should really ensure that it focuses broadly on protecting human rights, and that it doesn't have a narrow focus on the misuse of computer networks and dissemination of objectionable information. I think that where we are in the world and what's happening in cybercrime, it needs to be more broadly focused. And then finally, I want to add my own words to the member from St. Mary who spoke about accession to the Budapest Convention. The truth is that Jamaica as a jurisdiction, we have partnered with the Budapest Convention, with Pegasus and a number of other initiatives, but yet we have refused to accede to the bill. The truth is, and sometimes to the convention, the Budapest Convention. The truth is that often I hear our leaders saying that this is a convention that is more in tune and meant for bigger countries, more developed countries, and for Europe, etc. The truth, though, is that there are other Commonwealth countries that have acceded to the convention, yes? Even right here in the Caribbean. And as I said earlier, Jamaica has partnered with the Budapest Convention on projects like Pegasus and all of that. And they have noted immense benefit, yes, from the international collaboration and from the technical support that we have received under the Budapest Convention. So I want to place those on record, Mr. Speaker, as in terms of my opinion and my hope in terms of what I'd like to see in the future around a cybercrimes bill.
Member from St. Andrews Southern.
Thank you, Mr. Speaker.